Good morning. Bill, will you close the door? Thank you. Welcome to our third session on preparing for finals. Today, we're doing Wills 101. Everything you've ever wanted to know about a will. And it's kind of basic stuff. We're not going to get very complicated. I'm going to, in a few minutes, interview Kim Smith, who graduated from the Arkansas Law School about 40-some years ago. Spent a good deal of his time at the prosecutor's office, and then became the county prosecutor, and eventually became a circuit judge. He retired a few years ago. Now he stays out of Nancy's hair, does some little jobs here and there, does some pro bono work for veterans who are in need. And I've asked him to sit in here and tell us all about wills. Now, he's going to give you a disclaimer. He says he doesn't know anything about wills, but he's had 6 months to brush up. Right?
Right. I took the wills course about 43 years ago, and they just, the laws changed, and I practiced, as he said, in the prosecutor's office 12 years, and the circuit judge bench for 26 years, and I tried civil cases and criminal cases. I didn't do any domestic relations, divorces. I didn't do any probate, which we're going to talk about today. But I have studied up on it for 6 months. So if I can't answer your question, I'll try to find the answer. I'll give you an email when we get ready to adjourn, and you're welcome to email me, and I'll try to find the answer.
Okay. All right, now begin. We're going to do some just basic stuff. Kim, what is a will?
Well, a will is the document that passes on your wishes as to how your assets should be treated upon your death. And in Arkansas, to be a legal will or valid will, you have to be 18 years or older. You have to have two witnesses to attest, two attesting witnesses, which means they sign a little certificate that they've seen you sign this will in their presence, and it has to be your last will and testament that you executed it and dated it.
Mm-hmm. Well, it says about assets. Well, what about the liabilities? Does the will take care of liabilities too?
Well, your administrator, your estate, or your executor has the duties to marshal the assets and also to pay your bills and your taxes. They won't miss the taxes.
Okay. Do I have to have a lawyer to write a will?
You don't. I highly recommend you have one because, for instance, if you had a wayward child that you wanted to disinherit, if you don't mention it, at least that was the law 44 years ago, if you don't mention that child specifically and cut them out of the will, then they could take under the will if they're not mentioned. The law presumes you just forgot about them when you didn't put their name in there. So there's some kind of quirks like that that I highly suggest you go to a lawyer. Mm-hmm. And you know, they charge different fees. Some have a set fee. Some will do it by the hour. But on the front end, you know, get that straightened out. Almost all of them will talk to you for free on an initial consultation, so they can find out, you know, the size of your estate and try to figure out how much work might be involved in preparing the wills or the documents.
Okay. All right. Now suppose husband and wife move here from California to be with the grandchildren. They have no intention of going back to California, but they had a will executed in California, and one of them dies while in Arkansas. Is the California will valid?
It is. You can probate the estate if it has to be probated, and we'll talk about that in a little bit. We have a statute in Arkansas that if you prepared that will legally under California law, you did all the steps, had all the witnesses, attestations if that's required there. If it's valid at the time in the state you made it, we will recognize that Arkansas will. Or if it meets our criteria with the witnesses, et cetera, then we'll recognize it, of course, as a valid will.
What is probate?
Well,
When Betty and I had our will executed, the lawyer said, well, now you've just avoided probate.
well, usually that's something good to do, especially if you have over $100,000. There is a small estate that can get streamlined if it's under $100,000. If it's over, then it usually takes 6 months to do probate. But it's essentially it's the court supervised authentication of your will, making sure it's a valid will, and then it recognizes your executor who marshals the assets, as we talked about, pays your bills, ultimately distributes the remainder of the estate to the beneficiaries that you've named and in the manner that you want them to take. If there's certain personal items you want certain beneficiaries to have, rings and that sort of thing, then it's a good idea to mention them in the will, unless you give them to them beforehand, And some people don't like to do that. If there's several siblings, then sometimes it causes some rift that Mama wanted me to have that ring. No, she told me she wanted me to have it. Anyway, if you put it in the will, there's no argument about who gets it. But the court has to supervise the distribution of your assets. Now, there's ways to avoid, as you said, you went to an attorney who probably created a trust for you, or there's other ways to do it. You can create a trust, and the trust gets all your assets, your real property. Like we changed we wrote a quitclaim deed to our real property and put it to the trust. Now, Nancy and I are still the trustees, and you have three people in a trust. You got the trustor, or the maker of the trust, trustee who oversees the trust, and then the beneficiaries, which of course are the children. And they can be a successor trustee after we die, and then because the trustee's got to distribute it upon our death, the trust. Mm-hmm. So you, Chuck Walling, don't own that anymore. The trust does, and you can put all your assets, and I think it's better to name them specifically in there. You can put an addendum that says, here's the assets that I want. Or some people just use a general, all my personal property and all my real property. But I think it's highly recommended to put at least real property, hold them in the name of the trust. And I think our vehicles are too, the trust owns the vehicles. Mm-hmm. But that's one way to avoid. If you don't have a whole lot of assets, you can put a pay on death, like on a bank account, or you can, like Nancy and I are joint owners of our bank accounts. When I die, she automatically gets that bank account, so it passes. You don't have to probate it because it's already passing the title to your that asset. But so it gets kind of complicated, and I try to rack my brain all the time to make sure if I got that put in the trust, because if you don't, you have to go through probate. And that's a minimum of 6 months, and there's 120 days. You have to put a notice in the paper that so-and-so has died. If you're a creditor or claiming money against his or her estate, you've got 120 days to file that claim with the court. And that's a long way to talk about probate, but that's essentially the court supervises the distribution of your assets pursuant to the will.
Okay. Well, what happens if someone dies and they don't have a will?
No will at all.
No will at all.
Okay.
What happens then?
Well, then the law tells you how the property is distributed. And it says if, say you have 3 children and they're all still living, so they're equal. So each of them, it's called, you take per capita. Each of them gets a third, say, if you have the 3 children. If one child has predeceased you, then they take per stirpes, which means the 2 equals, the 2 children, well, they all get a third, but it's called per stirpes, and so the deceased child's children would get his or her 1/3, and they'd have to split it up how many children they take equally, and it gets kind of complicated going on down there. But basically, that's what it is.
Okay.
So the law will equally distribute the property.
Now, suppose I have a will, and it's been 10 years since I had it executed, and I decide to make changes. Do I have to have a whole new will? Can I just add an amendment to it, or
You can. It's called a codicil.
a codicil?
And it has to have the same requirements. You've got to be 18. There's got to be 2 attesting witnesses. And you have to be specific try to be as specific as you can on what you're changing. I don't do them, but I would try to reference the paragraph in the will that you're wanting to change so it's really clear. If not, the law usually will do that for you. You know, if 10 years later you decide to give a ring to another child, well, it revokes the previous part of that other will. It doesn't revoke the whole will, just the one talking about that particular asset. So you can make changes, that way. And, sometimes it happens. I think for a long time, we didn't have the 3rd child in there by name, although she would have taken. But so we finally got her. We changed the will to include her. So it's a good idea to take a look if you have a will and it's been out there a while, to take a look at it and make sure that's exactly your wishes.
What is power of attorney?
Power of attorney is a mechanism where you designate someone to do your wishes. And there's several kinds. There's a general power of attorney, which usually deals with your assets. And we have a statute that I know there's some note takers. I'll read it off to you. You can go look it up. Any of these, if I give you a statute number, you can go to Google and put ACA, which stands for Arkansas Code Annotated, and you put these numbers in, and it ought to pop it up for you. There's several sites it'll go to. There's a way you can go to I've gone blank on the name of this place in Arkansas that you can go, and there's also the statutes in there. But the durable power of attorney for business matters does have a big listing of how you can, it says, do it in this form. And you can copy and paste what parts of the forms you want. And that's it, ACA 28-68-301 if you wanted to look at it. I still recommend you go through an attorney, but everybody has the right to represent themselves, but, you get what you pay for. It's kind of like when I try to do the plumbing at home, I'll do it, and then it leaks, and I'll go hire somebody to go buy the pipes again and do it. But
is there power of attorney for health care?
there is. There's a specific power of attorney for that, and that's at Arkansas Code Annotated, ACA, 20-6-103. Well, that's the law. It doesn't have exactly a form anymore. There used to be one. If you have done a medical power of attorney in the past, it's still valid. There's a statute that says that. We had a new durable power of attorney forms for medical passed in 2013, and then they passed another one in 2017 that doesn't really have the detailed forms as much, but it has the provisions that, again, you have to have 2 witnesses to the durable power of attorney medical, and I think they have to be attesting witnesses again, or you can have it notarized. One of the 2 things. If you can have them all notarized, I think that's better. Then there's not much question about it. But you can do that, and that will name someone to make your health care decisions if you become incapacitated. Okay. And there's also a medical directive in the statutes that you can say, I don't want nutrition withheld, or I do want nutrition. If I get, it's something to the effect, if I have a terminal disease, or I become unconscious and I have a terminal disease, I don't want nutrition, I don't want hydration. That's a medical directive, and that's in the statute too.
Now, there is a copy of the statute on the table in the back.
For the medical directives.
And a medical directive.
And that's the one, that's called sometimes the living will. A lot of these terms are interchangeable. But the living will usually refers to the directive as to nutrition and hydration. That I do want it, I don't want it, and the medical providers are statutorily bound to follow it unless they feel it's in not medically proper. Then they have to give you notice that I'm not going to follow it, so you can try to get someone else, assuming you're still.
Is the medical directive legally binding?
It is.
It is.
It is.
On the doctor?
The doctor, a medical care facility.
The family?
Family.
Okay. Now, Malcolm Hayward, in our workshop on Saturday, is going to spend some time going through various scenarios in helping us prepare our medical directive. Under what circumstances do you want hydration? Under what circumstances do you not want hydration? Under what circumstances, like if you had pneumonia, do you want antibiotics for the pneumonia if there is no chance of you surviving? But he's going to go through a variety of scenarios that will help us write our own medical directive. And the medical directive can also be your wishes as to if you are in a coma and you want music played. Well, you can put that in the medical directive. You know, I'm going to put in my medical directive that I want to listen to the Dodgers baseball game. Some will want classical music, some will want country music or whatever, but you can make those kind of decisions in the medical directive, and it's binding if it has been notarized and also witnessed. It's binding on the facility, it's binding on the doctor, it's binding on your family.
In some instances, you can do it orally too if you don't have one. It's provided for in the statutes. It's harder to do, but I would recommend you have a written medical directive, especially if you want country music. It'd be binding on Nancy, so I wouldn't. She probably wouldn't go along with that. But she'd have to, wouldn't she?
Okay, Charlie, you got the microphone? Questions from the floor. Over here.
I guess it works. Is it working?
Yeah.
Okay. Who can be the executor of your trust?
Anyone that will agree to serve in that capacity. Of course, you want to get try to pick someone that you trust that will there's a fiduciary duty created when you do that, and you name a trust an executor that has to follow your directives. They're statutorily bound to follow what they believe to be your wishes and your directives if you have them in writing. But you want someone you can trust. They don't necessarily have to live in the town that you're in. I think it's easier, but they don't have to. If you had an out-of-state relative or an out-of-city relative that you wanted to be an executor.
Would it be a good idea for the lawyer to fill that role?
I prefer.
Go ahead. Would it be a good idea for perhaps your lawyer to fill that role?
Some people do. I think it's better if you have a family member that you can nominate to serve without pay. You have to specifically put that in, and they have to agree to serve without pay, because it does take some time to do those things. But their duty is to administer your will or your trust, whichever way it's set up. And some have both. I have a will that, we have a trust, and then we also have a will. But that person has the authority to hire an attorney to walk them through, if it has to go through probate. And I recommend that. And again, if you're an executor and you're hiring an attorney, go get a free consultation and find out, what are you going to charge for this? Are we going to do it on hourly? There's also an executor attorney fees that are statutorily mandated that have percentages of the estate. And I recommend not doing that if you can. Some of them, if it's a big estate, get up pretty high. But I recommend getting an attorney. My wife's parents one's in 90 and the other's 89, and I'm an executor with her brother. And of course, the whole family's going to look at me and say, well, you just do this. And I'm going to have to tell them, I don't know anything about doing a trust or probate. We're going to have to hire a lawyer. And I've tried to let them know about that beforehand. But anyway, I highly recommend you talk to a lawyer about it. There's some that's all they do, and their fees aren't as high as some others. You can get them, you can go make an appointment with 2 or 3 of them and compare what they're going to charge you.
Mm-hmm.
Judge Smith, is there a magic number? You mentioned $100,000, so that you, if you had those assets or above, that you would probably try to avoid probate. If there was a fast track for probate at a lower amount, is there a magic number that you would suggest, or that is known in your community, to create a trust of assets, magic number of assets?
I really don't know. If you have a smaller estate, then it's easier to do a pay on your death clause, with a bank account or savings account. Another mechanism that would transfer that ownership upon your death, as opposed to having to create a trust. But some of them that are standard, the attorney that does them a lot, they probably have a flat fee that maybe, $2,500 you could get a will and a trust made up. I don't know that number. I'm just kind of pulling that out. But you can ask them.
Yeah, actually, it's not the number. it's not the number you'd pay to the attorney.
No, I know. The
It's
number,
the
how much in
number
the
of how much
estate.
asset you have
Right.
in the state.
Well,
like $1 million
yeah,
or $3 million,
yeah.
or what would that be?
I think it's good. Well, you know, for someone that doesn't deal in this really and didn't ever do any cases, you know, my guess is if you have a couple of $100,000 worth of assets, you might look to put it in a trust, because as far as the cost of the trust compared to having to go through probate and wait 6 months, you know, that's kind of the main bugaboo. Plus, it's public record. If you want your assets held private, you know, people not knowing what you have, you know, it doesn't bother me, but some people it does. But it's public if you have to go through the courts to probate your estate. You know, any Tom, Dick, and Harry go down there and look in the file, and well, now it's all electronic. But anyway, they could get in there and look if they want to.
So I need this dumbed down a little bit. If I have a will, my estate goes through probate no matter what. Is that correct?
Assuming your assets, like,
Or over 100,000?
well, yeah, you still go to it's called a small estate. It still has to get probated, but
But will means some form of probate, trust? means
usually
to
it
avoid
does.
that. Okay.
I mean, if all your assets were in a pay on death or another mechanism that passed it title to your property, like if all you had were some bank accounts and you had, you know, your spouse is going to get them if they're on that bank account, so that wouldn't have to go through probate. But it just depends on what assets you have.
If my will says everything goes to my kids, does it still go to probate?
Probably will. Mm-hmm. And you know, some people, it's all right. I mean, the court's supposed to look after, to make sure your executor, you know, marshals all the assets and pays your bills and distributes it how you want it distributed in your will. So, you know, that's why we have it. Usually it's real large, complicated kind of trust or estates that really benefit from a trust. Because ours isn't that big, but we have one. But anyway, just because I wanted the kids to get whatever it is faster, you know, instead of waiting 6 months. Okay?
When you have an executor appointed, are they automatically have power of attorney as well?
No, that's separate.
Okay, thank you.
Well, but of course, when you die, your executor manages your assets. But you can also have a power of attorney, but there's a durable power of attorney that they can still act after you're gone. And that's getting kind of complicated. But anyway, it's called a durable that lasts.
If you get all these documents done, but it's been a while, are they still valid, or do they need to be reviewed occasionally? And if so, how often?
They're probably still valid. As I said, there's statutes that every time they change the requirements on how you do a will or how you do a trust, there's almost always a statute that says if you did yours before this date, when it changed, it's still valid. If you did it pursuant to the law that was in effect at that time. So assuming your attorney or whoever did your will, you can have a holographic will, which means you write it down, and the law will recognize that if you have to have 3 people that can verify that's your signature.
Well, I had all this done with a lawyer about 2002, and so...
You're probably good, but you might want to, you know, look at it. You know, you've got a copy, I hope.
Yes.
There's a mechanism, if you do a holographic will, you can pay $2 and go file it with the circuit clerk, and she or he keep that document for you, and there's certain regulations on when they can release it and who they can release it to. But you can look at your own. You know, if you really want to have peace of mind, you might want to, if that lawyer's still in practice, or find another lawyer. And how much would you charge me to review this will to make sure? And, you know, some of them are getting $400 an hour anymore. Most of them are probably $150 to $300. But, you know, talk with them up front. I know I should have gotten to private practice, I guess, but no.
My other question was coinciding with hers about what your estate actually is. If you've got your bank accounts all set up on pay on death or transfer on death, that's not considered part of your estate?
Well, it's your estate, but it doesn't have to be probated. I mean, it won't be put in probate.
No, because it'll already be,
Right, it'll already pass. Well, yeah, if you want to define the estate of what's left after you die, then it's out of your estate, because it passed, it went to the
Okay.
named pay on
Okay.
death,
thank you.
okay?
So you spoke about it transferring to children, but if you're married and you have a spouse living, it goes directly to the spouse, right? Or is it probated then?
Well, part of it
Depending on-
does.
I mean, depending on your will, but
Right. Like my will, everything goes to Nancy. And same with the trust. She and I are co-owners of that trust. So she'll be the owner of the trust, although there's still beneficiaries after she goes. But sometimes the spouse will automatically get a half. And under certain circumstances, and now you need to ask somebody that has more knowledge about than me. But you know, if you have a will, it'll go per your request. You know, if you have a surviving spouse and that you put that in the will, then they would get all the estate.
But it's probated before they get it? It's probated
no.
before they get it? That's what I'm asking. It doesn't go
I see.
automatically to a spouse?
You know, that's something I don't know the answer
Okay.
to. But if you want me to try to find, I'll call some lawyers I know that know the answer. You get a hold of me. I'll put my email out there.
Okay.
For a trust, in addition to the initial filing or initial setup fee with the attorney, is there annual filing or annual cost and annual filing requirements?
No, not until, there's no annual payment for the trust once it's set up. You know,
Well, for example, if you had the trustee as a bank, wouldn't there be a
oh,
fee?
and the bank will charge you money to do that. But
and there's
I
no-
don't know how, if it's annually you pay them a fee, or,
And is there a filing, an annual, you know, with the IRS as far as the trust?
it goes through you're the owner of the trust until you die, and you pay it through your taxes. There's not a separate tax filing, at least that I've not seen. I'm not a tax lawyer, but you know, we don't file any extra IRS things for the trust. Now, when you die, I assume you would. I mean, I know there's taxes that have to be paid.
Thank you. So when you go to pick your lawyer to help you, we have a will drawn up, but we haven't spoken to that lawyer in years. I don't even know if he's in business. And then you read about there's elder law lawyers.
There are.
Would that be, when you're older, like beneficial to engage that type of a lawyer, or just how do you find someone?
Well, that's becoming a specialty, elder law, especially as we baby boomers, get up there. They know a lot about the Medicare and that sort of thing, and you know, when you die, if you try to give your property away to your children so Medicare will pay for a nursing home for you, there's a 5-year look back. Even if you have a irrevocable trust, which means, irrevocable trust, which means you can't ever get it anymore. I mean, you can't, if you decide you wanted some money out of it, you couldn't get it. And they used to do those for some tax consequences, but on death. But now you don't see those that much because they've raised the amount that you and your wife, I think, have $6 million together, and $3 million apiece, and $6 million jointly, before some taxes come in. I'm not sure that answered your question, but tell me again what it was.
Basically, how do you find
Oh, a lawyer,
an
yeah.
attorney to help you
Okay,
update your
well,
will
there's-
or do
yeah.
your will? And should you, so an elder law attorney isn't
Right.
necessarily.
I'd ask friends and see who've dealt with them. Ask around. There are some ratings, I think, there's a Martindale Hubbell that has a rating of attorneys, and that's based on other attorneys' recommendation, and judges. As a judge, I would get them in the mail for so-and-so attorney. Do you rate him? The highest on ethics is AV, and then they rate on their abilities. And you can look at Martindale Hubbell. You could probably just Google it and try to find out that way. But I think the best way is to ask friends and family about an attorney.
There are my lawyer, and there are certain others that give a consultation with you before you put out the particulars, and there's not a charge for that.
Right. Yeah. Initial consultation, almost all of them will do it for free. You know, they'll give you 30 minutes to find out what your questions are and how much it may cost you. And I highly recommend you do that and make sure you and the attorney both are clear on, you know, what the charges are going to be, hourly or flat fee, and what the work is involved. But they will do that for free. They'll meet with you and you can find out. And how long they've been out in practice, I think, helps. I mean, I know some attorneys that I recommend that only been out 8 or 9 years, but they've been doing it. I know they're honest and they're smart, and, you know, I recommend them under certain, not necessarily for probate or wills and estates, but other things that I don't have a problem with young lawyers that have been out at least 7 or 8 or 9 years that are real good.
Let me repeat something that Evan said 2 weeks ago, and that is surveys have shown, when asked, is it important to have a will, 90% of 100 people will say yes. When the same people are asked, do you have a will, the number drops to 30%. And the same thing is true of a healthcare proxy, a healthcare directive. People think it's very important to talk about that stuff, but when it comes to actually doing it, there's a great gap. Or as Abraham said, there is a great chasm for it. So think about your will. One of the sessions on Saturday will be about what you have to do before you go to the lawyer to write your will. And it is not as simple as it sounds. But Ms. Clausen is kind of an expert in that area of the law, and she does this quite often, and she's going to spend an hour encouraging us how to get ready to write your will. And that'll be the second session, I think, on Saturday morning. There is a clipboard in the back there of a list of people who have signed up for the Saturday workshop. What we need to know, if you will look at that list, if you have any dietary restrictions, please note it on next to your name. If you have not signed up, please do so that we can plan on how many tables, how many chairs, how much coffee, and how much lunch. And lunch will be provided. Any other questions?
My question is, there's a lot of confusion about trust and Medicare/Medicaid. Is your trust protected?
No, and you have to count that, as I understand the law, that you have to count that. Most trusts are revocable trusts that are created, like Nancy's and mine is revocable. So if we decided we wanted to change a beneficiary, you could, if you had a wayward child again, you wanted to cut out, like I talked about cutting them out of the will, well, you could cut them out of the trust. You could change your trust. So that's revocable. It can be revoked. But there's the irrevocable I talked about that can't. And an irrevocable trust might save you that asset. In other words, if you put something in an irrevocable trust, your house, and that might save it from Medicare counting it against however they figure whatever. And I don't know how they do that. The elder law people do know that. And if you have those issues about wanting to see about, going into a nursing home and what are they going to count, but I know there's a 5-year look back if you try to just give your property to your child 4 or 5 years ago, your house, and you said, well, it's not mine, I don't own it anymore. Well, they'll look back 5 years.
Any other questions? Looks like we're done.
I'm sorry that I put you on the spot.
That's all right.
But thank you anyway for coming
All right.
and
Well, great.
being here.
Well, I hope they got something out of it. Thank you. There they are.